Hey guys, what is up? So I'm going to continue reading the Trading of the Enemy Act book, but let me put in my headphones first. Just give me a moment. Remember, this is for educational and entertainment purposes only. Alright, give me 1 minute. Let me just put my headphones in because otherwise you guys... Alright, so if anybody does want to follow along, I am on page 46. So, in foreign exchange, export or earmarkings of gold or silver coin or bullion or currency, transfers of credit in any form other than credits relating. Good. How are you doing? Let me just turn my Wi-Fi on. Saying reconnecting. Hopefully it's good. All right. So, where was I? Let me just start over. In foreign exchange, export or earmarkings of gold or silver coin or bullion or currency, transfers of credits in any form other than credits relating solely to transactions to be executed wholly within the United States, and transfers of evidences of indebtedness or of the ownership of property between the United States and any foreign country, whether enemy, ally of enemy, or otherwise, or between residents of one or more foreign countries by any person within the United States, and he may require any such person engaged in any such transaction to furnish under oath complete information relative thereto, including the production of any books of account, contracts, letters, or other papers in connection therewith, in the custody or control of such person, either before or after such transaction is completed. Section 6. That the President is authorized to appoint, prescribe the duties of, and fix the salary not to exceed $5,000 per annum of an official to be known as the alien property custodian, who shall be empowered to receive all money and property in the United States due or belonging to an enemy or ally of enemy, which may be paid, conveyed, transferred, assigned, or delivered to said custodian under the provisions of this act, and to hold, administer, and account for the same under the general direction of the President and as provided in this act. The alien property custodian shall give such bond or bonds, and in such form and amount, and with such security as the President shall prescribe. The President may further employ in the District of Columbia and elsewhere, and fix the compensation of such clerks, attorneys, investigators, accountants, and other employees as he may find necessary for the due administration of the provisions of this act, provided that such clerks, investigators, accountants, and other employees shall be appointed from lists of eligibles to be supplied by the Civil Service Commission and in accordance with the Civil Service law. Provided further that the President shall cause a detailed report to be made to Congress on the first day of January of each year of all proceedings had under this act during the year preceding. Such report shall contain a list of all persons appointed or employed, with the salary or compensation paid to each, and statement of the different kinds of property taken into custody and the disposition made thereof. Am I still breaking up, or is it good now? Let me know if anybody can, please. Section 7A. That every corporation incorporated with the United States and every unincorporated association or company or trustee or trustees within the within the United States issuing shares or certificates representing beneficial interests shall, under such rules and regulations as the President may prescribe, and within 60 days after the passage of this act, and at such other times thereafter as the President may require, transmit to the alien property custodian a full list, duly sworn to, of every officer, director, or stockholder known to be, or whom the representative of such corporation, association, company, or trustee has reasonable cause to believe to be an enemy or ally of enemy resident within the territory, or a subject or citizen residing outside of the United States of any nation with which the United States is at war, or resident within the territory, or a subject or citizen residing outside of the United States of any ally of any nation with which the United States is at war, together with the amount of stock or shares owned by each such officer, director, or stockholder, or in which he has any interest. The President may also require a similar list to be transmitted of all stock or shares owned on February 3rd, 1917 by any person now defined as an enemy or ally of an enemy, or in which any such person has any interest. And he may also require a list to be transmitted of all cases in which said corporation, association, company, or trustee has reasonable cause to believe that the stock or shares on February 3rd, 1917 were owned or are owned by such enemy or ally of enemy, though standing on the books in the name of another, provided, however, that the name of any such officer, director, or stockholder shall be stricken permanently or temporarily from such list by the alien property custodian when he shall be satisfied that he is not such enemy or ally of enemy. Any person in the United States who holds or has or shall hold or have custody or control of any property, beneficial or otherwise, alone or jointly with others, of, for, or on behalf of an enemy or ally of an enemy, or any person whom he may have reasonable cause to believe to be an enemy or ally of enemy, and any person in the United States who is or shall be indebted in any way to an enemy or ally of an enemy, or to any person whom he may have reasonable cause to believe to be an enemy or ally of an enemy. Okay. Whew. It's like that. They between this in this entire book, that's like all they repeat over and over and over. So just something to really focus on. Anyways, continuing on. Shall, with such exceptions and under such rules and regulations as the President shall prescribe, and within 30 days after the passage of this act, or within 30 days after such property shall come within his custody or control, or after such debt shall become due, report the fact to the alien property custodian by written statement under oath, containing such particulars as said custodian shall require. The President may also require a similar report of all property so held of, for, or on behalf of, and of all debts so owed to any person now defined as an enemy or ally of an enemy on February 3rd, 1917, provided that the name of any person shall be stricken from the said report by the alien property custodian, either temporarily or permanently, when he shall be satisfied that such person is not an enemy or ally of enemy. The President may extend the time for filing the lists or reports required by this section for an additional period, not exceeding 90 days. B. Nothing in this act contained shall render valid or legal, or be construed to recognize as valid or legal, any act or transaction constituting trade with, to, from, for, or on account of, or on behalf, or for the benefit of an enemy, performed or engaged in since the beginning of the war and prior to the passage of this act, or any such act or transaction hereafter performed or engaged in, except as authorized. Wait, I just lost my spot. I'm so sorry. 1 second. Shit, where was I? Authorized hereunder, which would otherwise have been or be void, illegal, or invalid at law. No conveyance, transfer, delivery, payment, or loan of money or other property in violation of Section 3 hereof made after the passage of this act, and not under license as herein provided, shall confer or create any right or remedy in respect thereof, and no person shall, by virtue of any assignment, endorsement, or delivery to him of any debt, bill, note, or other obligation, or chose in action by, from, or on, or behalf of, or on account, or for the benefit of any enemy or ally of enemy, have any right or remedy against the debtor, obligor, or other person liable to pay, fulfill, or perform the same, unless said assignment, endorsement, or delivery was made prior to the beginning of the war, or shall be made under license as herein provided, or unless, if made after the beginning of the war and prior to the date of passage of the act, the person to whom the same was made shall prove lack of knowledge and of reasonable cause to believe on his part that the same was made by, from, or on behalf of, or on account of, or for the benefit of an enemy or ally of enemy, and any person who knowingly pays, discharges, or satisfied any such debt, note, bill, or other obligation, or choose in action shall, on conviction thereof, be deemed to violate section 3 hereof, provided that nothing in this act contained shall prevent the carrying out, completion, or performance of any contract, agreement, or obligation originally made with the or entered into by enemy or ally of enemy, where prior to the beginning of the war, and not in contemplation thereof, the interest of such enemy or ally of enemy devolved by assignment or otherwise upon a person not an enemy or ally of enemy, and no enemy or ally of enemy will be benefited by such carrying out, completion, or performance otherwise than by release from obligation thereunder. Nothing in this act shall be deemed to prevent payment of money belonging or owing to an enemy or ally of enemy, to a person within the United States not an enemy or ally of enemy, for the benefit of such person or of any other person within the United States not an enemy or ally of enemy, if the funds so paid shall have been received prior to the beginning of the war, and such payments arise out of transactions entered into prior to the beginning of the war, and not in contemplation thereof, provided that such payment shall not be made without the license of the President, General, or Special, as provided in this act. Nothing in this act shall be deemed to authorize the persecution of any suit or action at law or in equity in any court within the United States by an enemy or ally of enemy prior to the end of the war, except as provided in section 10 hereof. Provided, however, that an enemy or ally of enemy licensed to do business under this act may prosecute and maintain any such suit or action so far as the same arises solely out of the business transacted within the United States under such license, and so long as the license remains in full force and effect, and provided further that an enemy or ally of enemy may defend by counsel any suit in equity or action at law which may be brought against him. Receipt of notice from President to the effect that he has responsible ground to believe that any person is an enemy or ally of enemy shall be prima facie defense to any one receiving the same in any suit or action at law or in equity brought or maintained to any right or set off or recoupment asserted by such person, and based on failure to complete or perform since the beginning of the war any contract or other obligations, and any prosecution under section 16 hereof. Proof of receipt of notice from the President to the effect that has reasonable cause to believe that any person is an enemy or ally of an enemy shall be prima facie evidence that the person receiving such notice has reasonable cause to believe such other person to be an enemy or ally of enemy within the meaning of Section 3 hereof. C. If the president shall so require any money or other property owing or belonging to or held for, by, on account of, or on behalf of, or for the benefit of an enemy or ally of enemy, not holding a license granted by the president hereunder, which the president, after investigation, shall determine is so owing, or so belongs, or is so held, shall be conveyed, transferred, assigned, delivered, or paid over to the alien property custodian. D. If not required to pay, convey, transfer, assign, or deliver under the provisions of subsection C hereof, any person not an enemy or ally of enemy who owes to or holds for or on account of or on behalf of or for the benefit of an enemy or an ally of enemy, not holding a license granted by the president hereunder any money or other property, or to whom any obligation or form of liability to such enemy or ally of enemy is presented for payment, may at his option, with the consent of the president, pay, convey, transfer, assign, or deliver to the alien property custodian said money or other property under such rules and regulations to the president shall prescribe. E. No person shall be held liable in any court for or in respect to anything done or admitted in pursuance of any order, rule, or regulation made by the president under the authority of this act. Any payment, conveyance, transfer, assignment, or delivery of money or property made to the alien property custodian hereunder shall be a full acquittance and discharge for all purposes of the obligation of the person making the same to the extent of the same. The alien property custodian and such other persons as the president may appoint shall have power to execute, acknowledge, and deliver any such instrument or instruments as may be necessary or proper to evidence upon the record of otherwise acquittance and discharge, and shall, in case of payment to the alien property custodian of any debt or obligation owed to any enemy or ally of enemy, deliver up any notes, bonds, or other evidences of indebtedness or obligation, or any security therefor in which enemy or ally of enemy had any right or interest that may have come into the possession of the alien property custodian, with the effect as if he or they respectively were duly appointed by the enemy or ally of enemy, creditor or obligee. The president shall issue to every person so appointed a certificate of the appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States. Whenever any such certificate of authority shall be offered to any registrar, clerk, or other recording officer, federal or otherwise, within the United States, such officer shall record the same in like manner as a power of attorney, and such record or a duly certified copy thereof shall be received in evidence in all courts of the United States or other courts within the United States. Section 8A. That any person not an enemy or ally of enemy holding a lawful mortgage, pledge, or lien, or other right in the nature of security in property of an enemy or ally of an enemy, which by law or by the terms of the instrument creating such mortgage, pledge, or lien, or right may be disposed of on notice or presentation or demand, and any person not an enemy or ally of an enemy who is a party to any lawful contract with an enemy or ally of enemy, the terms of which provide for a termination thereof upon notice for acceleration of maturity on presentation or demand, may continue to hold said property, and after default may dispose of the property in accordance with the law, or may terminate or mature such contract by notice or presentation or demand served or made on the alien property custodian in accordance with the law and the terms of such instrument or contract, and under such rules and regulations as the president shall prescribe, and such notice and such presentation and demand shall have in all respects the same force and effect as if duly served or made upon the enemy or ally of enemy personally. Alright, I'm going to stop this video so I can save it. I'll be right back and we'll continue page 52. 1 second, be right back.